This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner. And on behalf of Judges Bennett and McBrayer, we welcome Mr. Roberts and Mr. Bulso to this oral argument, which we are live streaming in order to fulfill our obligation to maintain open courts. We will conduct our hearing in the same manner as if we were in the courtroom together. Each of you has 15 minutes, and Mr. Bulso has reserved some of that for his rebuttal. Unless there are announcements, I'll ask Mr. Hibner to call the case.
The Wise Group, Inc., et al. Versus Dwight, Holland, et al.
All right, Mr. Bulso, you have the floor.
Thank you and good morning. May it please the court, my name is Nicholas Bulso. I represent the plaintiff appellants here, the Wise Group, Inc. and the Lux Development Group, LLC. This is an appeal arising from two orders of the trial court below. The first was the trial court's June 18, 2020 order, which set aside an earlier order of the court dated April 13, 2020. That order set aside the dismissal of Dominion's counterclaims. The second order was the trial court's September 4th, 2020 order, granting Dominion Real Estate LLC's motion for summary judgment. I'm going to address those orders in reverse chronological order, so I'm going to start with the summary judgment motion. The plaintiffs, pursuant to Tennessee's codification of the Uniform Fraudulent Transfer Act, which is codified at Tennessee Code Section 66-3-301, asserted fraudulent transfer claims against multiple defendants, including Dwight, Holland and Dominion Real Estate LLC, centered on the transfer of property located at 4329 Central Pike over in Hermitage, Tennessee. Dominion Real Estate and defense argued the affirmative defense that's provided by Tennessee Code Section 66-3-309A. That section provides that a transfer or obligation is not voidable under Section 66-3-305A1 against a person who took in good faith and for a reasonably equivalent value, or against any subsequent transferee or obligee. So that section provides a two-part defense. The transferee must take in good faith and must give reasonably equivalent value. Dominion Real Estate moved for summary judgment on its affirmative defense. And so though generally a plaintiff bears the burden of proof, because Dominion moved on its affirmative defense, Dominion bears the burden of proof. So according to the Supreme Court's decision in TWB Architects, Dominion Real Estate must produce in the summary judgment record evidence that, if uncontroverted at trial, would entitle it to a directed verdict. The burden then comes back to the plaintiffs, who then must produce evidence to show that there is a genuine issue for trial, or that a rational trier of fact could find in their favor. And as the Supreme Court stated in Byrd v. Hall, in determining a motion for summary judgment, the trial court does not weigh the evidence or determine whose evidence is stronger. The trial court is strictly charged with confining itself to the determination of whether a rational trier of fact could draw one and only one conclusion from the evidence presented. And when the court granted Dominion summary judgment on motion on September the 4th, 2020, the court noted the three facts on which it based its grant of summary judgment. The first was that at the time Dominion purchased the property, the plaintiffs had not recorded a judgment lien from case number 18C-1007. That's the plaintiff's original case in the circuit court. The second fact was that the payment of $350,000 by Dominion for the property greatly exceeded the plaintiff's $35,124.24 judgment. The third fact was that the only facts that the court considered in terms of Mr. Holland expressing to Mr. Vaughn that he had had some problems and conflicts with Mr. Wise were insufficient to put Dominion on notice. And so, beginning with that first fact, the trial court was plainly in error on that. The record shows that the plaintiffs filed their judgment lien on June the 3rd, 2019. That was after the circuit court entered its final order on April 30th, 2019. And so, pursuant to Tennessee Rule of Civil Procedure 62.01, the plaintiffs filed their judgment lien approximately 30 days later. So again, that was on June the 3rd of 2019. Dominion Real Estate didn't actually purchase the property or close on the transaction until a week later, on June the 10th of 2019. And Dominion actually was deeded, Dominion was deeded the property the next day on June the 11th of 2019. So the plaintiffs had filed their judgment lien a week before Dominion purchased the property. The court just committed plain error there. As to the second fact, the record shows that the court did not apply the appropriate test. The court determined that the $350,000 judgment, or the $350,000 payment, exceeded the plaintiff's judgment, and that fact is simply not relevant. As the bankruptcy court explained in Ray Webb Mountain, reasonably equivalent value involves the common sense evaluation of whether a party gets roughly the value it gives as measured against market reality. Whether a given plaintiff's judgment is equal to, more than, or less than the amount transferred does not affect whether an alleged fraudulent transfer got roughly the value it gave. But even given that the relevant nature,
what evidence was there presented to the trial court here of the market realities at the time of the closing?
The plaintiffs presented both testimony from Dominion and then two offers that Dominion received for the property, in which Dominion actually substantiated during its deposition testimony. So Dominion, again, purchased this property on June the 10th of 2019. 3 months later, it listed the property with Keller Williams with an asking price of $1 million.
So we can just assume then that that's the proper measure of valuation 3 months prior to that date?
Well, when Dominion purchased the property, and then as Dominion testified during its deposition, did not make any improvements to the property. So 3 months later, the property is in the same condition as it was when Dominion purchased it. As Dominion said in this deposition, they cut the grass, but didn't.
Why wouldn't the right answer here have been to present testimony of appraiser or some other evaluation expert that said, as of the date of the closing, this property had a fair market value of X? I mean, I realize reasonably equivalent value is not the same as fair market value, but this record doesn't seem to have a lot in terms of what the valuation was at the date of the closing, other than the price that was paid.
There's evidence on both sides of that, because back in January of 2019, when Dominion first started talking to Dwight Holland about this, Dwight Holland actually appraised the property, and as the owner of the property, he said that this property, with the proper zoning in place, would be worth $1 million. At the time he made that statement, he didn't realize that the Metropolitan Planning Commission had already approved a new overlay for that area. So the zoning change there is already imminent. It just needs to be baked into a special order, a special policy change.
Had all that occurred by the time of closing?
The special policy amendment went into effect August the 30th of 2018. It was already in effect. And then
the zoning, you're telling us the zoning had already changed then at closing?
The specific overlay applicable to the property had changed. There still needs to be a zoning ordinance change. But
okay, so there was something left to do before that valuation could be realized.
Yes.
Okay. So really, that's based on an assumption that had not occurred as of the date of closing.
It's a little less than an assumption, Your Honor. As we've pointed out in our briefing,
it's a sure thing.
Yes, it's okay. Imminent. And then the offers we presented from Ryan Homes and Beezer Homes have actually already priced that in, because they know that the Metropolitan Planning Commission is going to approve that property for a greater mixed use, a mixed development use than just the single residential property as it's zoned right now. And so when they offered $1,023,000, and then Beezer Homes came in and offered $945,500, they've already baked into their offers that zoning change, which is something that they're entitled to do and which courts are actually encouraged to do. We cite to Nashville Housing Authority versus Cohen and PC Metals, which both stand for the proposition that these imminent zoning changes, which are considerably likely, should be taken into account when you're evaluating the value of property.
So is it your position here, turning to the issue of notice, that the judgment lien itself would have given Dominion actual notice of the claim here? And if so, why is that?
We've never actually argued that Dominion had actual notice of the judgment lien because there's no proof in the record that Dominion actually knew of the judgment lien. We've always focused on constructive notice.
I mean, even if they did, would that make any difference? The judgment was not against the owner of the property.
Yes, Your Honor. But as Dominion testified, Dominion at no point said, I am doing business with LAH LLC. I'm doing business with Dwight Holland. That's why all of the suspicious factors of this transaction did not bother him, because even if he's paying $30,000 to LD Consulting, which doesn't own the property as an earnest money deposit, even if he's agreeing to buy the property from LAH LLC, which doesn't own the property, which Dominion knows Americana Birds and Bees, which is a separate entity not controlled by Dwight Holland, even if that entity controls the property, it's all okay because I'm doing business with Dwight Holland. So Dominion is trying to escape that connection, but Dominion was never concerned with LD Consulting or LAH LLC. It knew it was doing business with Dwight Holland. And so our theory and our argument has been that these suspicious red flags that we identify should have triggered some concern in Mr. Vaughn, who then could have looked into Mr. Holland. Had he done that, had he even conducted a basic property title search, he would have found that judgment lien. He would have found out that Dwight Holland, who had some problems with Alan Wise, was actually being sued by Alan Wise because he had taken funds from Alan Wise's companies, which are the plaintiffs here, and used those funds.
But was Holland ever in the chain of title?
He was not, Your Honor.
So why would a title, if I'm searching title here and going back and I see LAH LLC, and I see Americana Birds and Bees, and before that I see LD Consulting LLC. I mean, I'm confused how a title search really helps out your case here.
A title search would not, Your Honor. As we've mentioned in our briefs, the perfunctory title search does not satisfy.
You really have to go behind. You have to do a little more digging, is what you're saying.
Yes, and we're saying, given all
and that digging would involve, well, first you need to connect the dots between Mr. Holland and his son, and know that Mr. Holland's son controls Americana Birds and Bees LLC, and you have to also know that Mr. Holland solely owned the predecessor LLC to the next one in the chain of title here. That's a lot of digging that you're asking a prospective buyer to do, isn't it?
No, Your Honor, because as we've gone through all of our analysis, we're only asking the actions of a rationally prudent person. And so what we're saying is that with Mr. Vaughn knowing Dwight Holland, knowing he is running this transaction, knowing all of the suspicious activities that he's conducted in actually trying to transfer the property, doing that quick title search is not a very burdensome request. It's what a rationally prudent person would do.
But you're willing to concede that the title search itself is not enough. You have to go even further beyond the title search.
Correct, Your Honor.
You have to hire an investigator to check it out.
That's why we focus on inquiry notice, which is not constructive notice by another name. It does require more than just constructive notice, which would be accomplished by a title search.
All right. Thank you, Mr. Bulso. We'll hear from you on rebuttal. In the meantime, we'll hear from Mr. Roberts.
Thank you, Your Honor. Can y'all hear me okay?
Yes, sir.
Your Honor, and I'd like to address Judge McBraier's question about the zoning, and I'd like to clarify something. The two issues of that. One, Mr. Vaughn, and I say Mr. Vaughn, I mean Dominion Real Estate. It's a singly owned entity. Mr. Vaughn, deposition testimony is very clear of two things. One, that the approval by the Metro Planning Commission of anything is not set in stone. It has to be approved by Metro Council, which had not been done. All the Metro Planning Commission does is make recommendations. And second, Mr. Bulso questioned Mr. Vaughn extensively about the need for additional zoning, and Mr. Vaughn was continuously clear that considerable more zoning was required and necessary in order to develop this property to its full potential. And to sort of suggest that somehow on June 12th that all the things were in place is simply not true and not reflected in the record. Second, to switch a little bit to the judgment lien question, let's not lose sight of the fact that Judge McBrayer, you're absolutely right. That judgment lien was never against the owners of the property. It was against Dwight Holland individually. And I submit that it is a huge jump that Mr. Vulso seems to suggest that a purchaser of real estate would require not just to go to the Register of Deeds, but to go not just to the county court, perhaps statewide or maybe even nationwide, to suddenly start trying to put together pieces. I asked this court to look very carefully at what happened on June 10th. And that's what my client is accused of. If you look at the complaint, it is confused, or Mr. Vaughn Dominion is accused of taking a conveyance, of paying $350,000 for a piece of property and somehow being part of a conspiracy to defraud the appellants. What did my client see? My client went into a title company run by an attorney, and he said in his deposition he relied upon that attorney to make the deal honest, to make sure that he was being protected and everything was legitimate. He went into that title company, sat down at that table, looked at a HUD statement, and what did he see? And the HUD statement is Exhibit 28 to Mr. Vaughn's deposition. He saw that his $30,000 deposit was reflected on the HUD statement as promised. And a lot of the focus of the appellants is, oh, maybe he shouldn't have written the check to Mr. Hall. It was on the HUD statement as promised. He saw the HUD statement had the name of LAH on it as the seller, exactly as promised and as written in the purchase agreement that was signed on April 3rd, or excuse me, May 14th. Mr. Wilson's made a big deal that the property wasn't conveyed from Americana to LAH until the 15th of May. Okay, but on June 10th, when my client purchased this property, everything was right. He had no reason whatsoever to believe there was any problem. The sale from the transfer from Americana, they weren't a party to this circuit court case. So, Judge Murray, you're absolutely right. The burden that's being shifted to my client is humongous. This sort of, you have to go read pleadings at the courthouse and draw conclusions and then go in and object to the purchase of a property. My client tendered $350,000 to purchase this property. Now, admittedly, part of that was cash and part of that was mortgages, but that is a perfectly normal transaction. There's nothing about this transaction that's remotely.
So did the HUD statement show Mr. Holland getting any distributions from this?
No, there were three mortgages, one from an independent third-party source that was the first mortgage, and LAH took back two second mortgages that were demand notes, could be called at any time, and which were paid off about 3 months later in September. So this was all of the $350,000 in its entirety was transferred within really 90 days.
Was there any conventional financing at all involved in this transaction?
Yes, the first mortgage of $85,000 was with a third party, and it was a hard money loan. It wasn't like from Regent's Bank or something, but it was a perfectly normal, common type hard money loan. And again, all of this was handled by the title company, and Mr. Vaughn had no reason, even if you take these, I don't even call them red flags, pink flags, salmon colored flags that Mr. Bulso keeps throwing out, everything looked perfectly right at the time my client was conveyed the property. And that's all my client's accused of doing, is receiving this property. And it was perfectly legitimate. As part of this, and I asked this court to pay very close attention to this, we make a reference in our brief, and I apologize for this, to an exhibit to a motion that was filed that apparently didn't get filed with the trial court. And I apologize for that. That was a mistake. However, it's very clear on record page 445, there's the response to this motion. And it says very clearly, the appellates say that if you don't mind reading this, they have not inspected the property. They don't know the conditions of the property. Without further investigation, cannot determine the development potential of the property. And they declined to speculate as to the dollar value of this property. This was in June of 2020. And in June of 2020, the appellants are admitting they've never looked at the property. They don't know what it's worth. They don't know what the potential value is. And they won't even speculate. And I like that word, is key, speculate as to its value. And yet they're willing to maintain a fraudulent transfer action against my client. all my client can say is, I thought it was a fair price and I paid a fair price. Certainly my client thought they could improve the value of the property and make additional funds of it. Obviously, they didn't buy the property to lose money. But we have an appellant who just refuses. And Your Honor, you were absolutely right when you said, couldn't they have gotten an appraisal? They could have gotten somebody to say what the value is. And that's why the court, in its order in September 4th, said they failed to refute or rebut the proof that we put forward as to the value of the property. Because the only value in this record is what my client was willing to pay and LAH was willing to sell. And that's before we even get into the fact that this was a payment of $350,000, 10 times the judgment amount. And I've never heard of, I mean, I've certainly dealt with fraudulent transfer cases before and read plenty of cases, but I've never seen a fraudulent transfer case where a buyer paid 10 times the judgment amount and is accused of defrauding a creditor, and then the creditor refusing to say what the property was worth. I don't know how we win. In fact, we tried very hard to get them to admit the property, and they simply refused to put that evidence in the record. And I don't understand why. I think it's because they didn't want to admit, or maybe they were afraid of what an appraisal would show. But that property was purchased on June 10th. It had potential value, but it had no realized value other than what the seller sold it for. Those offers that Mr. Bulso likes to refer to, and the deposition of Mr. Vaughn goes into depth about this. These were highly conditional offers. These were offers with 6 to 8 months of due diligence periods that didn't begin until zoning was completed, which might take 6 to 8 months. They then had generous extension periods and very little hard money down. That is not a cash offer or a near cash offer. That is a fantasy offer. That is a way of tying up the properties for months, if not years, in the hope that there will be changes in the development in that area and the properties will be worth that much. But at any time, any one of those entities could have walked away from those deals, got all their earnest money, small amount of earnest money back. Those weren't real offers. Offers, this considered, is what someone would pay. I think it's notable that the appellants never came in and offered any amount of money. There are no offers to compare. So we're in the unfortunate situation of trying to prove what a piece of property is worth when the appellants won't even give us a number to disagree with. And yet we're part of this lawsuit and we're trying to get away from these individuals.
There's some testimony in the record that at one point there was some discussion between Mr. Holland and Mr. Vaughn about structuring this transaction somewhat differently, where there would be some sort of partnership and development. Absolutely. Was that part of the summary judgment, or is that just extraneous information that's just on the record?
What happened is in January, when Mr. Vaughn met Mr. Holland, there was discussions about purchasing the property. Mr. Holland gave him a rough range of values. That came back a couple of months later. Mr. Vaughn, who's sort of new in the real estate, and that's in his deposition, wanted Mr. Holland to help him. And they had some discussions about possibly partnering, possibly staying on. But that's not what they did. Those were just one-time discussions in March. 2 months later, they entered into a purchase sale agreement, and it had none of those provisions. There was no going forward. Mr. Vaughn expressed his hope that Mr. Holland would help him going out, be his friend and his mentor going forward. But there was no continual participation. So, and this is one of their.
Does bankruptcy play in here at all in any respect? Does bankruptcy play at all in any respect here?
I'm sorry, what play?
Does bankruptcy play any role here?
We didn't really. That came in after the lawsuit was filed in July of 2019. That did cause some confusion because Mr. Vaughn did think that the case was being dismissed, and I think it was either put on hold or but that was long after the sale. And Mr. Holland told Mr. Vaughn not to worry about it. Now, he should have worried about it, but he sort of trusted Mr. Holland.
So what sort of bankruptcy did Mr. Holland file, and was that still ongoing or?
No. It was dismissed very quickly thereafter. I truly believe Mr. Holland did it as a stalling tactic, although I don't know that, but it wasn't a real basis for it. And part of that, quite honestly, Your Honor, is that Mr. Holland had just received $350,000 which would, and he owned, and both in cash and notes that would have been assets in his estate. So he wasn't insolvent. It's not that you can't file bankruptcy without being insolvent, but it's generally not done. So at that time, they want to treat this like a fraudulent transfer. But what did Mr. Holland, through his entity LAH, have on June 12th or 11th? He had $120,000 in cash and two notes worth $250,000. No attempt was made by the appellants to try to levy on those notes. No attempts was made to try to levy on the money that was actually paid to Mr. Holland. Instead, they just filed a lawsuit and have been relentless in pursuing this lawsuit, despite the fact they've been paid in full, despite the fact that they don't even have an idea what this property is. They continue to go on, and they've admitted that all they want is attorney's fees and punitive damages against my client in a situation where all he did was buy a piece of property.
So, Mr. Holland is the sole member of LAH.
It's my understanding, Your Honor. Yes.
Right.
And I feel like in some ways have been trying to prove a negative. How do I prove that my client didn't know anything about Mr. Holland or his problems with Alan Wise individually? He just says he didn't. And no proof was put in this record. Well, the one thing about this record is it's very one-sided. It's Mr. Vaughn, either through his affidavits or deposition, saying, I didn't know anything about these people. I only knew Mr. Holland. I trusted Mr. Holland. And I might note Mr. Holland did everything he said he would ever do for Mr. Vaughn. And yet we can't seem to get away from these folks. Whatever fight they have is their fight. And I'm sorry that Mr. Wise and Alan Wise and Lux hate Mr. Holland. That's okay. But we didn't have any part of that. And they just want to keep us in. They just want to keep us in. And I would add that, this is, and I keep sort of focusing on this, the issue of the amount they paid. I think that's critically important. I've not read a single fraudulent transfer case where someone paid 10 times the amount of the judgment and could be held to be defrauding that creditor. Part of the arguments of the appellants is that once Mr. Dominion or Mr. Vaughn paid this $350,000, that somehow they had this ongoing duty to protect the creditor in this case. And I just think that's wrong as a matter of law. The only obligation my client had was to pay the cash at closing, the notes off, and he fulfilled that obligation. What Mr. Holland did with the money, or his entity did with the money, may be a fraudulent act by Mr. Holland or LAH, but there's not even an allegation that my client was involved in any of that. I don't know how we get away from these people, but if this court puts a burden on my client or all real estate purchasers to research statewide court records and read pleadings and try to draw some sort of nebulous conclusion that some entity they're buying property from has some lawsuit that should make them not purchase a piece of property, I think that's just too high a burden. And lastly, Your Honors, I would say that one of the things that struck me odd about this case is, what if Mr. Vaughn had known? What if Mr. Holland had said, I owe money to Wise and Lux Development, to the appellants. I owe them $35,000. I need to sell this property right now to pay them off. What would my client have done any different? He would have bought the property. So all this constructive notice stuff is really sort of a red herring. I would have told my client to buy the property and let Mr. Holland satisfy his obligation. Thank you.
All right. Thank you, Mr. Roberts and Mr. Bolso. Your rebuttal.
Thank you, Your
Be
Honor.
sure to unmute. There you go.
And so, as the court has just heard, Dominion has approached this case from the perspective that it only had to look after itself. But of course, Tennessee Code Section 66-3-309 requires good faith. And so, as Mr. Roberts just said, Dominion is looking out for itself in this transaction, and that has consequences, because even if Dominion paid LAH 10 times its judgment, it paid it to LAH. It didn't pay it to Dwight Holland, and therefore we, the plaintiff appellants, could not execute on it. We could not enforce our judgment against it. As a matter of fact, Dwight Holland filed bankruptcy to try to get away from us and prevent us from getting to that money. We had to go in and have his bankruptcy case thrown out, and he was barred from filing bankruptcy again for 6 months.
But you could have, I mean, I guess the answer there, though, is you could have garnished LAH. I mean, it seems like to me that'd be the thing to do.
We didn't have a judgment against LAH, Your Honor. We didn't have.
But you don't have to have a judgment against the garnishee. I mean, you got a judgment against Mr. Holland, right? And you can say, LAH, pay any funds that you owe to Mr. Holland to us because we have a valid judgment. I mean, that's how garnishment works.
Well, be that as it may, Your Honor, after we had Dwight Holland's bankruptcy thrown out, LAH actually paid the underlying judgment and satisfied that judgment. And so moving on from there, I just want to focus again on another issue we brought up, and that's the dismissal of Dominion's counterclaim. As we put into the record, Dominion consciously permitted the dismissal of its counterclaim and then tried to get it back later on when we came back to seek attorney's fees. As we pointed out in Discover Bank, a party cannot engage in willful conduct, permit dismissal, then come back and try to undo the very thing that they permitted just to get some sort of a tactical advantage. And so, Your Honor, I mean, for all of these reasons that we've given, we're requesting that this court reverse the trial court and then remand for further proceedings.
Mr. Paulson, let me ask you a quick question about what you said about LAH paying the judgment. Which judgment did they pay?
The circuit court judgment from case number 18C-1007, our circuit court case judgment.
So they paid off the $35,000 that was owed by Mr. Holland.
LAH paid off Dwight Holland's judgment.
Okay. All right.
All right. Thank you, Mr. Bulso and Mr. Roberts, for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 10:30 a.m.